Great. Okay, so good afternoon. My name is Beth Whitman, and I am today's moderator for this MDTC presentation. I am an appellate practitioner with the Kitch firm in Detroit. As I'm sure you all know, Tim Deemer is an appellate practitioner with the law firm of Jacob and Deemer PC in Detroit. He has extensive experience in appellate law and has practiced nearly 20 years as an appellate specialist. So for today's presentation, please use the chat feature that's located at the bottom of your screen, and I will field all the questions during the presentation. We will have time for questions at the end of the presentation, but the hope is that we can incorporate your questions throughout the course of the presentation and make this presentation as interactive as possible with this virtual format. So without further ado, go ahead, Tim.
Thank you very much, Beth, and thank you all for coming. From the list of attendees, we have a nice mix of a number of appellate specialists and a number of trial attorneys who are less frequent appellate practitioners, which is good to see. So we'll try to cover some kind of inside baseball content, as well as some nuts and bolts and tips and strategies for the less frequent appellate practitioner. As Beth mentioned, there's a chat function. I really hope it's not just me yammering at you for an hour, and that it is more interactive. Beth and I have worked an outline out together, so she knows what's going to be covered at which point. So if you send a question, she might filter it and raise it at the appropriate time during the course of the presentation. So again, please send your questions. They're greatly appreciated. So yeah, today's topic is going to be interlocutory appeals. And when I first thought about doing a presentation on this topic, it was back in January, and I started to jot down notes and what I intended to cover. And back then I figured that 4 months later, here in May, I would be talking about how, well, there's been a few trials here and there, but that there's still a backlog. And boy was I wrong. The opposite's true. I know maybe Grand Traverse and a couple other counties have had sporadic civil jury trials here and there, but the rest of the state, we're still on hold. Wayne County Circuit Court had a real push, and I know a number of attendees on here felt that push back in March to get trials going in March, and then things got worse, and we're back on hold again. And the earliest trial that I've heard for March is going to be trials at the end of June, and even then, if that date holds, the plan is to only have 2 courtrooms open for trials. So I bring this up. I know we all live with this pandemic every day, and we're sick and tired of it. But I bring it up because until we start getting back in the courtroom and until it's safe to have jury trials, there are very few final orders to appeal from, and there are no final orders to appeal from, from a fully litigated case before a jury. The practice of law at the moment and foreseeable future is limited to motion practice. Again, jury trials have not resumed, and when they do, the priority is going to be given to criminal trials because the whole Sixth Amendment thing. So the backlog in civil cases is enormous, and it might be some time before your client can get its day in court with a trial. So that was the genesis of this presentation, but even under normal circumstances, my personal view is that interlocutory appeals are underutilized, and there is a system-wide preference to have appeals from final orders. This preference for appeals from final orders is codified in the court rules. MCR 7205 governs interlocutory appeals, but although there's a preference for an appeal, one final appeal from a final order, as opposed to the piecemeal approach, this preference is not as strong as is commonly understood. If anything, there's been a trend towards a more flexible approach to interlocutory appeals in the right circumstances. Now, again, this is my personal opinion, but I think the misperception stems from the federal system. The federal system, it is a very, very strong preference to wait until a final order is entered. And although the Michigan rules are based in a number of respects on the federal rules, this is one instance where Michigan stands kind of on its own and is much more amenable to interlocutory appeals than you would find in federal court. Again, the court rule 7205 would require the interlocutory appellant to show two things. One, that the trial judge committed an error, and then secondly, that the appellant would suffer substantial harm if forced to await a final judgment before taking an appeal. In other words, you have to convince the court that you should not have to wait until the case is over before you file an appeal. Again, that's the federal rule and the federal standards are not that much different. The language is awfully similar, but unless you have a statute or a court rule, or it's a qualified immunity issue, for example, in a 1983 case, in the federal system, it's a waste of time, it's a waste of money, and ultimately a waste of credibility to file interlocutory appeals, because they're really not, the Sixth Circuit really is not interested in taking your case, again, except in limited circumstances. There's a court rule governing class actions, has a specific provision authorizing interlocutory appeal from a class certification decision. Again, qualified immunity is another example. That's an interlocutory appeal. The only other instance might be where there's literally a bell that cannot be unrung. The district court requires the party to turn over a trade secret or confidential information or something like that, that once it's released, there's literally no way of getting relief on a post-trial notice of appeal in the federal system. I'm frequently called about an interlocutory appeal in the federal system, and my advice 99 times out of 100 has been, don't bother. It's not worth it, and you're only going to upset the district court, you're going to upset the Court of Appeals, because they really are not interested in taking it. And again, I'm going to contrast that with the Michigan system. Again, I cited the standard earlier, but there's a lot of anecdotal knowledge and knowledge from experience, as well as knowledge you can gain from speaking with the Court of Appeals judges themselves. Every 3 years, there's a bench bar conference, it's called, where you get the appellate judges, the appellate justices, and the appellate practitioners. They get together every 3 years to discuss best practices in the appellate system. And it's kind of an interactive event. Judges and justices hear from us, and we hear from them about how the court could be improved. And it's at these conferences that you can hear among the 28 different Court of Appeals judges, very different views in terms of when that particular judge may be inclined to grant an interlocutory review. There are some judges that have more of the federal view that interlocutory review is rare and it's limited to extreme circumstances, but that seems to be a minority view among the Court of Appeals judges. And there are some judges who have just candidly said, I don't really care about the substantial harm factor. If you show that the trial judge made an error, I'm going to grant your appeal. So that's again kind of an extreme view on the other end, with most judges being somewhere in the middle. But that's a kind of a far cry from what you will find in the federal system. And even between the judges themselves and their view on when an interlocutory appeal might be warranted, there's also kind of a district by district difference. We have a Detroit district, we have a Lansing district, and when you file an interlocutory appeal, it does not go to a pool of 28 judges of the Court of Appeals, it goes to that particular district. So for example, an appeal out of Wayne County is going to go to the Detroit district office, and it'll be Detroit district judges who decide whether to grant your interlocutory appeal. If it's an appeal out of Livingston County, for example, it would go to the Lansing district. You'd have Lansing judges deciding. So even within the judges, there's differences. And Beth mentioned this to me, and I think it's a great point. I hadn't thought about it until she said it, but it does appear that the first district out of Detroit is a little bit more activist in terms of granting interlocutory review. So again, when you file an interlocutory appeal, it's going to go to 3 randomly drawn judges from your district. You don't know who they are until they get the application in their hands and make a decision. But don't operate on the assumption that there's going to be a reluctance to granting your appeal, because there are plenty of judges who would be happy to take a case if you can simply show that an error had been committed. The decision of whether to grant or deny an interlocutory appeal is resolved in an unpublished order of the Court of Appeals. These unpublished orders are not available on Westlaw. They're not available on Lexis. They are available on the court's website, but the search function does not have the bells and whistles and search functions of a commercial search engine like Westlaw or Lexis. And even then, an order denying or granting an application typically just features a one-line statement. If there's case law is not cited, things of that nature. It's not like an opinion. It's also like a precipice order, granted or denied. And if there's a dissent from the decision, the statement of the dissenting judge again is very limited. It's the judge says, I would have decided whether to grant or deny it differently than the other two judges. So you can't really discern too much about your case based on the content of an unpublished order, granting or denying the application. There are two different, essentially boilerplate orders that are issued by the court, and I'll address those later. Ordinarily, it's not a problem which order you get, but sometimes it can be, and I'll talk about that but later. But again, to me, the important thing is the Michigan Court of Appeals, it's flexible. They will take an interlocutory appeal if you present substantial harm and you show the trial judge made a mistake. Don't operate on the assumption that it's not worth your time and that you're better off waiting until the case is over to file your appeal. So there's one other reason. Again, this is anecdotal, but I did some digging into this, and it appears to be borne out about why I'd recommend a more aggressive approach to interlocutory appeals. It has nothing to do with COVID. It has nothing to do with the lack of jury trials. And this dynamic underlying this rationale for pursuing interlocutory appeals has been percolating in the system for a number of years, long before the world came to an end in March of 2020. The other reason I recommend filing an interlocutory appeal and not waiting for a final judgment or final order is the fact that recently there has been a reluctance to overturn full-blown jury trial results in the Supreme Court of Michigan. And that's especially true if there is a substantial jury verdict or money judgment attached to the trial proceedings. Again, this is a stark contrast to when I first started practicing almost 20 years ago. At that point, the appellate courts did not hesitate to overturn trial results. They did not hesitate to take away verdicts from the plaintiff's bar. Partly, there's been a change in the composition of the court that I think explains the reluctance for the Supreme Court, especially, to step in and overturn a trial. Again, it's partly just different ideological leaning of the judges and justices in the appellate system. But it's a factor not as common as they used to be. And aside from the ideological composition of the courts changing, I think the other reason that overturning a jury verdict or a substantial money judgment is more difficult is that, again, going back 20 years, when I first started being an appellate lawyer, the judges were viewed, the judges and justices were viewed, rightly or wrongly, as tort reform warriors. And this caused great consternation between the judges, justices, and the lawyers. It caused consternation between the plaintiff's bar and the defense bar, and that kind of hostility carried over into personality disputes between the judges and justices themselves. And again, this is purely my personal opinion. I have no inside knowledge of this, but I think part of the reluctance of the courts to step in and take away jury verdicts is to get away from that kind of toxic environment that had been developed. And honestly, as a policymaking court, the Supreme Court does not care whether its policy is made on a summary disposition appeal or a full-blown jury trial. If the court wants to make a new rule of law, they can do it from a summary disposition appeal, which is not that controversial. But that same ruling would be extremely controversial if it arises from a $20 million jury verdict or something. So again, thinking back to the good old days of 10 years ago, Gilbert versus Daimler Chrysler, Pellegrino versus Amco parking systems. Those were cases with tens of millions of dollars at stake, and the Supreme Court took those verdicts away. They don't appear to be doing that nearly as often as they used to. And again, this was just kind of my anecdotal experience, my personal view. So to prepare for this presentation, what I did, I wanted to see if that proved to be accurate or not. The Michigan Supreme Court lists all of its opinions released by terms. You can look at 2021, you can look at 1920, 1920, 1819, on, and it will show and list all 23 to 26 opinions that were released during that term. And honestly, I'm stunned to see just how infrequently the Supreme Court's getting involved in full-blown jury trials. Again, I looked at the major decisions working backwards from the Michigan Supreme Court. One of the more important opinions in the last 5 years was Elher v. Misra. It's a major 702 expert witness qualification decision. It was from an in limine order. It wasn't overturning a jury verdict that was based on faulty scientific evidence. It was an in limine ruling that the Supreme Court took. So then I scanned the court's opinions, again, going back to the last 4 terms, and here are the major civil opinions that the court's issued. Wigfall versus City of Detroit. It was an interlocutory appeal of a summary disposition ruling on the question of notice under the Governmental Tort Liability Act. Dye versus Esurance, another interlocutory appeal of a no-fault priority dispute. It was also a summary disposition issue. Mimic versus Fortson, remedies for fraud in connection with the no-fault claim, another summary disposition appeal. Stenzel versus Best Buy, the relation back doctrine and the interplay of the court rule and statutes regarding non-parties at fault, another summary disposition ruling. Johnson versus Vanderkoy, summary disposition appeal regarding municipal liability. Bozzi versus Sentinel, interlocutory appeal, again, another fraud case in the no-fault context. This is what I found. I went back. I'm at my 4 years retroactive research at this point. I got all the way back to 2017, and I got very excited when I saw an opinion that was from a civil jury trial. It's the case of Spencer versus Farm Bureau, and it's an appeal from a jury verdict, but the jury verdict had absolutely nothing to do with the decision issued by the Supreme Court. It was a manner in which the lower courts had addressed attorney's fees under the contract at issue. So going back again over the last 4 Supreme Court terms, there's been one full-blown opinion arising out of a jury trial, and that appeal did not even impact the jury trial itself. It was the amount of attorney's fees. Again, you might wonder what any of this has to do with the focus of this presentation, which is interlocutory appeal to the Intermediate Appellate Court of Appeals. But again, if you look at those opinions that I just discussed, about half of them were interlocutory appeals. So the denial of summary disposition taken up in the appellate system, not just summary disposition granted, plaintiff appeals, and the defense against it. A lot of these cases are interlocutory appeals. So again, in my view, using recent history as a guide, if you and your client think you have a legal defense that would be dispositive or maybe limit the liability or limit the damages, my recommendation is get that issue in front of the trial judge early, long before trial. File your motion, whether it's summary disposition or partial summary disposition, get it in front of the trial judge early. And instead of waiting for a final order, because that final order might be after a jury verdict where there's millions of dollars awarded, if you get that issue in front of the trial judge early, long before trial, take it up to the Court of Appeals on leave granted. See if you can get any headway with on an interlocutory basis. Or, and then failing that, you can always appeal up to the Supreme Court on an interlocutory basis. And again, a number of those cases I discussed earlier, that's exactly how the procedure of the case went. So again, there's a reluctance to overturn big jury verdicts. Makes it less susceptible to reversal. But the other, again, this comes from practical experience. When you file an appeal in a multi-million-dollar damages case, and the case is pending in the Court of Appeals, you have an 18-month window before you get a decision. And during that time, there is enormous pressure on the defendant to settle the case. There are settlement procedures through the appellate system that people invoke, and they're very successful. And if you are going up on a case, again, using the example of a $10 million jury verdict, that's the starting point of your negotiation, is the $10 million. And that's an awful lot of pressure on the client, the carrier and the lawyer to get this case settled, because again, you don't know what's going to ultimately happen with your appeal. Now, on the other hand, if that issue that you would have raised on motion for JNOV, for example, had been raised in summary disposition, you have I think a more receptive audience to reverse, and you have a defendant that's more free to pursue those appellate remedies, again, without the pressure, the guillotine hanging over your neck of a huge jury verdict that you might have to deal with. And I can just, speaking from personal experience, cases that my partner and I have worked on over the years, where sometimes we're not involved in the case until after the jury has already spoken, and we can come in and file what we think is a really compelling motion for judgment notwithstanding the verdict, which again are way more often than not denied by the trial court. Take the case up to the Court of Appeals, and in the back of my mind, I'm sitting there thinking, I wish we could have raised this defense long before trial in summary disposition, taken it up to the Court of Appeals in advance of trial when there was not, a huge price tag on the case already. And setting aside just your run-of-the-mill trial results that you'd like to appeal, I know every appellate lawyer has a pet issue or two or three of law reform measures that the appellate lawyer would like to see changed. I know clients in in-house counsel have a number of law reform measures they would also like to see. So again, interlocutory appeal provides that opportunity to get that case, get that legal issue up in the appellate system without the jury verdict attached, without the price tag attached, to do it in this fashion. So you might have difficulty convincing a client or insurance carrier to be spending money early when it's not really needed. But if they have a significant issue that they would like to see, maybe some change in terms of the damages that might result from cases they're frequently involved in, or the interpretation of an insurance policy, for example, again, get that up there long before the trial result is what my recommendation is going to be. Again, appeals from trial results are still fruitful. There's still validity to doing that. And, the Court of Appeals has to take your case. You file a claim of appeal, they have no choice but to decide the issues presented. But if you want the Supreme Court to rule in your favor on a legal issue or a law reform measure, it's much easier to do it with a summary disposition appeal or something along those lines, again, without a jury verdict attached to it. So there are, again, interlocutory appeals, a long shot, less likely than more likely to be granted in any given appeal. But even if your appeal is unsuccessful on an interlocutory basis, it adds an extra layer of preservation to an issue that you might raise post-trial. And again, let's just assume there's a reluctance to reverse. If you go up on a post-trial appeal and you say to the Court of Appeals, look, we did everything we possibly could. We raised this issue on summary disposition, we raised this issue on reconsideration, then we came before the Court of Appeals on an interlocutory basis and we're not successful. Then we trialed, now we appealed. That removes some maybe natural incentive to find harmless error, as if the defendant didn't do everything the defendant could have done or avail himself of all the remedies the defendant might have. That's a really strong argument to say, hey, we tried everything in our power to prevent this mess from happening, and now we're before you as the last result. And filing an interlocutory appeal, earlier I discussed the pressure on the defendant who's got an appeal pending, again, for 18 months, a very long time to talk settlement with a price tag on it. Filing an interlocutory appeal is a pretty strong countermeasure of leverage the defense has against your opponent to file an appeal. That's a daunting proposition for any plaintiff and any plaintiff's attorney, the possibility that the Court of Appeals might take the case. And if they take the case, they might rule in favor of the defendant and reverse, again, for example, summary disposition. Or the appellate court might grant leave to appeal, and then the plaintiff and the plaintiff's attorney have to wait 18 months to get a decision. So there's, again, a lot of leverage that goes into taking this aggressive approach that can benefit your client and sometimes, drive home a more favorable settlement. Settlement demands, in my experience, get a lot more reasonable when you've got an interlocutory appeal hanging over one's head. So that's more of the background, kind of my strategic thought for why I wanted to do this presentation based on, again, in my experience. And I don't know, Beth, if there's any questions that come through on this topic, I'm happy to address, or I'm happy to move on to the next stage.
So far, there are no questions, so I think you can keep going.
Okay. Or then maybe it must mean everyone's asleep. Okay. Next, I'd like to move on to a discussion of which type of issues are best suited for interlocutory appeals and which aren't. A good appeal often arises out of jury instructions or an invalid jury verdict form or jury selection itself. Mid-trial decisions like these cannot be appealed on an interlocutory basis. There's no way the Court of Appeals is going to step in and intervene in the middle of a trial when the final order will be entered in a matter of weeks, if not days. So as mad as you might be about a jury instruction or a verdict form or the seating of a particular juror, those are the kind of issues mid-trial you've got to wait until the final order is entered. Preserve your issue, preserve your challenge to the instruction, the juror, or the verdict form, and then bide your time and file your appeal. Obviously, you can't interlocutory appeal from a excessive damages award. That's a post-verdict, post-trial remitted motion. Nothing you can do about that ahead of time. If your opposing counsel violates rules of fair play, things of that nature, again, the appellate court's not going to step in mid-trial and say to the plaintiff's attorney, you're being naughty. That's not going to go anywhere. Another category I would stay away from interlocutory appeals are discovery issues. Trial judges can't stand discovery motions, and I can assure you the appellate courts are even less interested in whether you should have to answer an interrogatory or not, or whether the question of deposition was fair. The appellate judges become appellate judges because they don't want to deal with discovery. So they're not going to be interested in taking your case. There is an exception. There's an exception to every rule. One would be, again, the bell that can't be unrung, the disclosure of trade secrets or proprietary corporate documents. If the judge is going to compel you to turn something over that you don't think you should turn over, and once you do, there's nothing you can do about it later, that's a perfect interlocutory appeal. That's substantial harm. That's kind of a textbook example. Believe it or not, this is kind of an odd order to think from an appellate perspective, but scheduling orders. I have handled a number of scheduling order appeals in my career. It's not, they don't arise out of, we're not ready for trial and the judge should have given us adjournment. Those types of scheduling order issues are not going to go anywhere, but there are a number of trial judges who use their scheduling orders as a weapon to deny, typically, again, this is a defense bar, so I'll talk from our perspective, your right to have a summary disposition motion heard and decided. And the way this is often done, I have seen one case where the judge just flat out said, no summary disposition motions in this case. That can't be done. You have a right under the court rules to file a summary disposition motion. The other instance I've seen is when a judge will have a heard by deadline for a summary disposition motion as opposed to a filed by deadline. The court rules allow filed by deadlines for summary disposition motions. But what some judges will do will say the summary disposition motion must be heard by, let's just say, August 1. You get your papers in order. You can file your motion 2 months in advance of the August 1 deadline. And what I have seen, some judges who will be unnamed will adjourn the hearing date that you've selected. You pick June 1 as your hearing date, and then the judge says, my docket's busy, pushes it back, and then goes and sets a hearing date sometime after August 1, and then all of a sudden says, hey, I had a heard by deadline, you didn't meet it, and I'm not going to even hear your motion. Well, obviously there's a reason why you could have a filed by deadline, because you are in control of when you file something, but a trial judge cannot use an arbitrary heard by deadline to deny you your right to file a summary disposition motion. I think the scheduling order appeals make for good interlocutory appeals because, again, the purpose of summary disposition is to weed out claims and or entire cases that should not go to trial. So if a judge denies you your right to file the motion, that's a really inefficient use of resources to have a trial on a case that maybe has no legal merit to it, or has a, some sort of affirmative defense defect, statute of limitations, release, something like that.
Tim, actually, we just got a question in.
Yes, great.
That kind of, I think, plays into this. From your experience, are there key issues, arguments, or buzzwords to use or not use when arguing the substantial harm issue on an interlocutory appeal of denial of summary disposition?
That is a very good question. I don't believe there's a recipe or a formula or buzzwords. I'll jump ahead a little bit in terms of what the outline I set forward. But when you file an application for leave to appeal, I try to adhere to a 5-minute rule, that if within the first 5 minutes of reading your application, you don't convince the Court of Appeals of why they got to do something about this injustice and why they got to do it now, that you'll lose them. You've got to. I start every application with an introductory section or a statement of the orders appealed from and relief being sought, where in the first 2 or 3 pages you lay out, this is what happened, this is why it's wrong, and this is why the court should do something about it now. You've got to do that right off the bat. I guess maybe there are some buzzwords, but again, if it's a summary disposition appeal, my recommendation is to say this trial should not go forward, and it's a waste of everyone's time. It's a waste of judicial resources to have this trial go forward. And the Court of Appeals should examine this legal question before we impanel a jury and go through a trial. So kind of a focus on efficiency, sparing resources is a strong argument. Those would be my focus. Every case is different, but that would be my focus. If it's, again, the scheduling order issue, tell the court, like, we don't know how the judge is going to decide this motion, but the judge has got to make a decision one way or another. And the benefit of a scheduling order appeal like that is, again, it's straightforward, it's simple to understand, it's grossly unfair, and the Court of Appeals in a case like that is not likely to grant your application, take additional briefs, from the parties, hold oral argument, and give a decision 18 months later about whether a motion should have been heard. Typically, the Court of Appeals, if you get relief, is going to be a order of peremptory reversal, which simply says we reverse the trial judge's scheduling order, or we reverse the order striking the summary disposition motion. Or, these scheduling order appeals can take many different forms of what order you're actually appealing from. But typically, an issue like that will be an unpublished order of peremptory reversal that sends it back to the trial judge, who is very happy to see you when you do appear to argue your summary disposition motion. Again, that's just a fact that weighs in favor of interlocutory review. Is it's a one sentence, one paragraph order that doesn't require full briefing and all the other things that go into a full-blown appeal. And that's just on a practical tip. If you do file an application for leave to appeal on an issue like that, you don't have to separately file a motion for peremptory reversal. The court has the authority to order a peremptory reversal just by the filing of a motion. Just by the filing of an application itself. You don't have to separately file a motion for peremptory reversal. If you do, the court's happy to take your $100, but it doesn't get you anything else. Your $100 motion fee, but it doesn't give you any extra ammo. Just ask for it in your application paper. And again, put that in your first 5 minutes. If you can crystallize the issue, what you're asking for and why they should give it to you in 2 pages, you're in good shape. And it should conclude with, we're just asked for a peremptory reversal, if that's what you're looking for. So in addition to scheduling order appeals, and the other type of order that I think is best suited to interlocutory appeal is going to be denial of summary disposition. And again, getting back to earlier topic, if you've got a legal defense to a claim, you raise it early. If you've got a law reform measure, raise it early. And this, again, this has to do with some of the factors I talked about earlier. But another one is simply that if you have a client with a legal defense, an absolute defense, again, think maybe a statute of limitations defense, or think of an open and obvious defense. There's another example. And you don't file a summary disposition motion on an open and obvious defense that you might have, and you wait to a directed verdict motion or a post-trial motion. The natural tendency of the trial court especially, but also Court of Appeals, is going to be, why did you sit back and wait when you could have raised this before? You've wasted everyone's time. You've wasted everyone's resources. How many attorney's fees have been spent? A judge and a jury sat through this trial for something that you could have raised in advance of trial. There's just going to be a reluctance to do anything to come to your favor. Again, there's no court rule, there's no case law that says this. And if anything, the court rule and the case law says the opposite. Summary disposition is subject to the same standard of review as a directed verdict motion or motion for J&OV. And there's case law that even says a sufficiency of the evidence challenge can be raised for the first time on post-trial motion. So there's a case that says you can do that, but that doesn't mean you should. And again, there's just going to be a natural tendency of the trial judge for sure. It's going to be a lost cause with the trial judge, but the Court of Appeals is going to have the same thing of like, you have this defense. Why did you sit back and wait when you could have done something about this? And again, I have one personal experience with this issue where there was an absolute defense to the claim that was raised, and it wasn't raised. My partner got involved in the case late, and we raised it, post-trial motion. But had we been involved in the case early on, I would say, hey, file the summary disposition motion. If it's denied, go up to the Court of Appeals, and I think it would have been received much more favorably, because I know that the trial judge was not happy. He's like, why am I only hearing about this now? You could have raised this. You could have spared me and the jury and everybody else all this time and effort. So there's no, this is just a purely practical tip from experience. There's no court rule case law that says this is how you should do it. But just in my experience, that's how you should be handling these things. Beth, I plan to hop forward unless there's any other questions that popped up on this.
No further questions at this time, so go ahead.
Okay, so I've highlighted nothing but the good things involved with interlocutory appeals. There are a couple of potential pitfalls to watch out for. One is just obvious; it's cost. It's not cheap. The filing fees themselves can be over $1,000 on some of the more complicated interlocutory appeals. You've got the attorney's fees involved with filing an additional brief in the Court of Appeals. But again, if the case is worth a lot of money, you can justify going upstairs on an interlocutory basis. But I had mentioned earlier that there are two different types of orders that the Court of Appeals will issue when an interlocutory appeal is denied. One says, again, it's very boilerplate, the application for leave to appeal is denied because we're not persuaded that we should take this case now. It's basically saying this is not one of the cases where substantial harm was shown, and you should wait until after the case is over until you have a final order before filing an appeal. There's nothing controversial about that. That's the way the system is supposed to work. And if you get an order that says the failure to persuade of the need for immediate review, no harm done. You're fine. There's no complications that are going to rise from that. Again, if anything, it helps. If on post-trial appeal, you say, look, we did what we could before trial and we didn't get anywhere. So now we're here as the last resort. Again, that's going to argue against harmless error. I just got a private message that says I look tired, so I appreciate that. The other little distraction there. The other type of order that you might get does have some negative consequences. If it's not failure to persuade of the need for immediate review, the order can sometimes say the appeal is denied for lack of merit in the grounds presented. And that can have some collateral consequences. There was a kind of a controversy for a number of years, and there were some unpublished decisions. They all kind of went back and forth, where some panels would say a merits-based denial of an interlocutory appeal constitutes law of the case as to those merits. So again, using open and obvious as an example, if you filed an application for leave to appeal saying this premises case should have been dismissed under the open and obvious doctrine, and the Court of Appeals panel says the application denied for lack of merit in the grounds presented, then you do file a claim of appeal from a final order. You could sometimes be met with a panel that would say, look, we already addressed the merits of your open and obvious defense, and we denied it, and we're going to apply a law of the case and not decide it differently. To me, that I never understood that argument. I never understood that point of view. In interlocutory appeals decided on briefs only. There's no oral argument. There's no opinion that's issued. There's no rationale for why there's a lack of merit. It doesn't, the interlocutory appeal doesn't go through the research division of the Court of Appeals like a full-blown appeal would. And for a panel to say that an unpublished order of that nature has the same weight and effect as a full-blown appeal, I never really understood that argument. It seemed unfair to me. But surprisingly, a recent published opinion settled the controversy and now says that if the interlocutory appeal says it was denied for lack of merit, then that is law of the case to a subsequent appeal from a final order. For anyone who's interested, that case is Pioneer State versus Mikulek, 330 Mishap 138. Again, this was in researching and preparing for this presentation, I saw this and was surprised to see that that's the manner in which the Court of Appeals has resolved this. Now, that's the bad news. But I will say that the bad news is avoidable. You can avoid an order with that type of language. Again, in my practical experience, a merits-based denial of an interlocutory appeal is extremely rare. And the order denying interlocutory appeals almost always failure to persuade of the need for immediate review. And again, that language poses no trouble. The Court of Appeals typically has the merits-based language in a denial order when the application was not timely filed. So an application has to be filed within 21 days of the order appealed from, or a timely filed denial, or a denial of a timely filed reconsideration motion. If an attorney misses the deadline for filing an application, the appellant must file what's called a delayed application for leave to appeal. A delayed application for leave to appeal must explain the reason for the delay. And if the delay is attributable to a blown deadline or a negligent mistake of a lawyer, the Court of Appeals will sometimes protect the attorney from professional problems by stating that the delayed appeal was denied for lack of merit, not because the lawyer made a mistake. I hope that makes sense. It seems strange that the court would take that step, but the Court of Appeals are sensitive. They don't want to get attorneys in trouble. They're not interested in doing that. And if an attorney files it on day 22, they can say, well, we didn't think there's any merit to this appeal, so we would have denied it anyway. If you got it filed on day 1, we would have denied it. So that they will sometimes take that extraordinary step to prevent the attorney from getting in professional problems. So again, in my experience, that's when you're going to see the lack of merit in the grounds presented language in an order. That Pioneer State case I referenced, I believe it was from, it was a delayed application situation itself. And if you timely file your application, the odds are not guaranteed, but it's virtually certain that if it's denied, it's going to be because it's going to have the failure to persuade of the need for immediate review language in it, not the merits. So again, I wanted to raise this as a potential pitfall to say that there is some downside risk, but if you follow the time frame that's called for and do everything you need to do to get your application on file perfected, you don't need to worry about that. I just saw a question pop up. I don't know if it's a good time for this before I move on to the next topic.
Sure. The question is, are there any hot topics that you're seeing the Court of Appeals taking up on application and or even avoiding?
That is a very good question. I mentioned this earlier that like all appellate attorneys, everyone kind of has their pet issue, their pet law reform measure. I will say that it seems the newly formed Supreme Court with Justice Welch taking the bench. It's been just basically 5 months, but it seems to me that they're more interested in civil jury trial issues. They have not issued, at least off the top of my head, I can't think of one, a major decision just yet, but they will be starting to issue decisions when the term is over in the end of July. But the cases they've taken, they are taking a lot more civil cases, and they are granting leave or argument on the application in cases that the former Supreme Court, former constituted Supreme Court was not. The prior court really seemed interested in pure legal questions of public policy. So summary disposition appeal without money judgment attached, those were what the Supreme Court was really interested in. Now it seems I have seen more negligence cases, more civil cases, and summarizing out of trial proceedings. And I can't predict what's going to happen, but it seems as if the fact that they're taking these cases, that there's going to be a more of an emphasis on issues of interest to MDTC and the right to jury trial, kind of a demarcation between judicial decision making and jury factual finding. That seems to be the focus. Now we can all think of 100 ways that those issues could be favorable to the plaintiff's bar, who are more inclined to want juries making decisions and not judges. And us as defense lawyers, we really prefer to have a judge make a decision on a legal question if we can, and avoid getting the case to the jury. That's our job, and that's what we want to accomplish. But there are some issues where, and I'm going to credit my partner, John Jacobs. And when I talked to him about this issue a couple months ago, he pointed me in the direction of some issues that are taking that preference for jury, giving jury the right to make decisions, not the judge or legislature. But there are some defenses that are codified in statute that if they were removed would be beneficial to the defense. He used an example of the 5% cap on comparative fault for failing to wear a seatbelt. I mean, that's basically saying if someone was injured in a car accident and would have been fine if he or she had been wearing a seatbelt, but because he or she did not, the comparative fault cap to 5%, that's grossly unfair to the defense bar. That's one issue he raised, which I thought was a great idea. So I think if you can identify issues to take up to the appellate system that wave the flag of jury prerogative that's favorable to the defense bar, those are issues I would focus on. And there are other examples, but that's one that my partner who raised it, I thought was a great idea. And I saw another question pop up. Is that a good time to answer that one before moving on?
There we go. Okay, couldn't unmute myself there for a second. Sorry. I think this maybe will lead you into the next, maybe the next section. The question is, will the panel that decides whether to allow the interlocutory appeal be excluded from the panel that actually decides the appeal?
Nope, and that is a very good question. Your application will be decided by 3 judges within the district that your trial court case arose out of. And then if the application is granted, it's then a random draw of all 28 judges of the Court of Appeals, and the 3 judges who decided the interlocutory appeal are not excluded. There's no rule to give them less preference or priority to serve. And sometimes it happens. It's statistically difficult to do, but you'll sometimes get the same judge on your decisional panel. And I have seen that same judge grant an appeal and then reject it, when it came time for the merits, which is an odd dynamic, but I've seen it happen. So yeah, that is a good segue, because I wanted to conclude with kind of maybe some more nuts and bolts of an application for leave to appeal, and that's a kind of a natural segue. So I know that when the notice of this event went out, sometimes it said 12 to 1, sometimes 12 to 1:30, but Madeline's has assured me we've got some wiggle room past 1 o'clock, so feel free to stick around past the 1 o'clock. So similar to a claim of appeal, I referenced this earlier, an application for leave to appeal must be filed within 21 days of the order appealed from, or 21 days from an order denying a timely filed reconsideration motion. So if June 1, summary disposition is denied, if you want to go right to the Court of Appeals, just get it in by June 22nd. If you file a reconsideration motion, make sure you get that reconsideration motion in on time, and then you can have 21 days from denial of reconsideration. Now, if you file an untimely reconsideration motion, let's say you file on July 1 and it's denied on July 6, you don't get to use the July 6 date. You're stuck with the June 1 date. You're going to be in the delayed application dilemma we discussed earlier. That the reconsideration itself has to be timely. Ordinarily, I do recommend filing a reconsideration motion for a number of reasons. You won't always have the benefit of doing it, but if you have the opportunity, and present day we do, because it's not like you're going to have a jury trial right around the corner, you're going to have the time to seek reconsideration. It's good for a number of reasons. One, if there's an argument or a piece of the record you'd like to make sure is part of the summary disposition ruling, you can include it on reconsideration motion. You're better off having done it the first time around, but reconsideration is better than nothing. Secondly, and these are again just pragmatic concerns, in a claim of appeal is a form. If a client called me at 4 o'clock on day 21, I could have the claim of appeal on file by 5 o'clock, no problem. The Court of Appeals will take a handwritten note in crayon and $375 and docket your appeal. You'll have some work to do after the fact to clean it up, but they'll take it. That's very straightforward and easy to do. An application for leave to appeal is not. It's a full-blown brief on the merits of the case. You don't file a claim of application and then get to brief it later. No, the application itself is the brief, and you've got to put a lot of time and work into it, and you have a 50-page limit. So if your intent is to file an application for leave to appeal, get the reconsideration motion on file, presume it's going to be denied, and during that time, you're going to have a lot more of an opportunity to get your application prepared, both the brief and the supporting documentation, which I'll get to that. I'll get that later. And then secondly, again, there's no court rule, there's no case law, there's no anything that says this, but if you are going to ask the Court of Appeals to give you the extraordinary relief of interlocutory review, you better tell them we gave the trial court every possible opportunity to get this right, and the trial court did not. And that is the only reason we are here, begging for interlocutory review. So again, it's kind of shows the Court of Appeals you're serious about this, and you gave the lower court every opportunity to do something about it before you came to the Court of Appeals. That kind of touches on the timing of a summary disposition appeal where the trial date's long into the future. Sometimes your interlocutory appeal is going to be, again, the scheduling order issue I discussed earlier, or it might be, again, a discovery-related issue. The judge instructed you and your client to turn over something that you think is privileged or confidential, or a trade secret, or none of the plaintiff's business, and you might have a abbreviated timeline. The judge might say you've got to turn this over in 28 days or something like that. If that's the case, you don't have time for reconsideration motion, because by the time reconsideration's decided, that 28 days will probably have come and gone. Now, one great thing about the Court of Appeals is if you have a kind of a day of reckoning that you're trying to avoid. Again, let's use the 28 days from now, you've got to disclose something. The Court of Appeals will get you a decision by day 27. If you file the appropriate documents, pay the appropriate filing fees, the court will work, and the clerk staff, the clerks for the judges and clerk staff will work their tails off to get you that decision by day 27. So a couple of practical tips if you are in that situation. One, if you're going to ask the Court of Appeals to, again, work around the clock to get you a decision by day 27, you better not wait until day 21 to file your application. If you are going to expect them to work around the clock, you better do so yourself. So again, using the disclosure of a document example, you've got 28 days to get that document turned over. Don't wait until day 21 to file it. The Court of Appeals is look at it and say, you expect us to act in 7 days when you took 21. Again, less inclined to rule in your favor. No, again, no court rule, no case law that says this. It's just getting the practical experience. And a lot of this comes from the appellate benchmark conference I mentioned earlier, where the court staff and law clerks, everyone's there, and they kind of explain, here are some of the things we like to see from you. And that's one. If you're going to ask us to give you a quick timeline, you better get us our everything early. Another tip is, if you're going to be in that situation and you get that decision from the trial judge to turn something over, the best thing to do is pick up the phone and call the clerk's office for the district where your application is going to be filed. Give them a heads up and just say, I had this decision in, let's say, Wayne County today, and you call the Detroit office of the Court of Appeals, and you simply tell them, I'm going to be filing a emergency application for leave to appeal to try to avoid this decision, and just let them know. They'll kind of get their internal documentation set up and be ready for it. And they will sometimes reach out to the opposing counsel and say, well, this is going to happen. So the appellant's going to get us everything in 14 days. We're going to give you 7 days to respond. And then the court's got a full 7 days to make its decision. If you wait and you just on day 14 file it and drop it in their lap, that they have to scramble, and it makes their lives a lot more difficult. So if you can make their life easier, do everything you possibly can. So in addition to filing an application for leave to appeal, again, the up to 50 pages of briefing, if it's an emergency appeal like this, where you expect a decision in a truncated time frame, you need to file a number of other documents, a motion for immediate consideration, and which is a $200 filing fee. If you don't have the hearing transcripts from the trial court's ruling, you have to file a motion to waive the hearing transcript requirement. That's another $100. If you're going to ask the Court of Appeals to maybe stay the ruling or stay the trial, again, using a summary disposition example as opposed to the document disclosure, and you're going to say, we've got a trial on August 1 and we want it stayed because we think you should grant this application, you need to file a motion for stay in the trial court. And if that is denied, only then can you file a motion for stay in the Court of Appeals. And that's another $100 filing fee. It's kind of the secret. The Court of Appeals docket is largely criminal appeals, where it's indigent criminal defendants and they don't pay filing fees or anything of the sort, and fees are waived. And the court, depends on the filing fees of the civil defense bar and the plaintiff's bar. So there's a lot of fees that go into an emergency appeal like this. But luckily, the court staff is extremely helpful. They will tell you what they need and tell you when to get it to them. And if you treat them well and get them everything as quick as you can, they're going to be accommodating as well. One other issue that's much better now than the good old days of 10 years ago, if you're going to file an emergency application for leave to appeal, it requires personal service on opposing counsel. So before there was e-filing, if you had to file an emergency appeal to avoid a trial that was supposed to start in 28 days or whatever time frame, it was kind of an all-day affair to get the paper copy of the application on file and then hand serve it on everyone else who's ever filed an appearance in the case. So sometimes if it's a case pending up north, it would require hand delivery of the application to the district that might be on the other side of the state from you, and then hand delivery on all the other attorneys involved in the case. So it would require, the lawyers, again, I'm a small law firm, so my partner and I would sometimes be driving all over the state, coordinating with each other. Did you go here yet? Did you go there yet? Just to get something on file. Now with e-filing, and I think probably 99% of attorneys registered for e-service in the Court of Appeals, that situation is gone. You can file e-file your application and all your supporting paperwork, and with a click of a button, it goes to everybody. Where it used to be you'd have to like plan your entire day around how you're going to serve everybody. Couriers, law clerks, people driving all over the state to get this done. It was also more difficult for the clerk's office because they would have to coordinate to make sure all these other people were served. Now a click of a button shows everybody's got it, timestamp at this point. They can act immediately. They can't act until everybody's been personally served. So e-service makes that a whole lot easier. And if you're in this circumstance where you're filing the application, motion for immediate consideration, motion to waive transcript, motion for stay, you might file those documents at different times. For example, if your trial date is 6 months from now, you can file your application. And then as the trial date gets closer, if the court has not acted on your application, then you have to file a motion for immediate consideration. Then you might have to file your motion to stay trial proceedings. So you could file everything at different times, but the court's going to decide everything at the same time. One unpublished order. And if the court denies your application, they'll deny the motion for stay. If the court grants your application, they'll typically at the same time stay trial proceedings. So you'll get a decision on everything all at the same time, again, leading right up to whatever day of reckoning you're trying to avoid. Do we have anything else pop up, Beth, or nope?
Nope, nothing else.
Okay, so again, I mentioned earlier that the application to appeal is much different than a claim of appeal, which is paperwork essentially. The application, if you're going to file one, start putting the pieces together ahead of time. If you file a claim of appeal from a final order, the Court of Appeals has all of the trial court record right there at its fingertips. If it's an interlocutory application for leave to appeal, the only trial court record is going to be what you provide to them. So as a rule of thumb, you obviously have to provide the order appealed from, which can be a complication I'll discuss in a minute. But if it's a summary disposition ruling, you want to attach your summary disposition brief, the plaintiff's response, and your reply so they know what issues were raised. If there's an opinion from the trial court, you want to provide that. So again, the Court of Appeals can assess the merits of your appeal. Any exhibits or deposition transcripts or anything that's important for your appeal, you attach it to the application and you file it. Again, they're not going to have anything that you don't provide to them. If you only provide them with your brief and the order, they're not going to know what's preserved and what's not. And that's not very helpful. You also have to file the docket entries of the trial court. And 99 times out of 100, when somebody calls me and says, hey, I got this defect letter, what's going on? It's because they forgot to attach the docket entries. It might seem like a small detail, but the docket entries that's how the court assesses the date the order was entered. Because again, the docket entries control, not the date of ruling was made on the record, for example. And then just any other jurisdictional issues that might arise. So you got to provide them with the docket entries. It used to be kind of a pain to get. Again, if I'm filing an appeal from a Grand Traverse County decision in the old days, I would have to pay somebody to go up to Traverse City and print them off and then send them to me. Now it's with everything being available electronically, it's a whole lot easier to do that. And it seems kind of strange, but you have to have an order appealed from. And again, that probably sounds odd, but there's one particular judge who's now retired, but he was notorious for making a ruling on the record and then refusing to enter a written order. And we all know the rule that the court speaks through its written orders. but this judge would avoid appellate review. I, again, say on the record and tell the defense lawyer, deny your motion for summary disposition, see it for trial in 3 months, and then not enter a written order. And if you wanted to appeal the summary disposition ruling, there was literally nothing you could do until an order was entered. And this judge had a reputation for doing it. And I know on the MDTC listserv, it used to be a topic of conversation. If you want to find out what it is, you can go through the archives. Fortunately, that's rare. This judge kind of had a bad, wasn't a positive on his reputation for doing it. And it's much less frequent to see that happen, but it still does happen. And I have one case in the last few years where there's exactly what was done. The judge made a ruling on the record. It was a summary disposition appeal and struck the summary disposition appeal. Struck the summary disposition motion and said, I'm not going to decide it. A motion for leave to file summary disposition was filed. That was also denied on the record, and the judge refused to enter an order indicating that the motion for leave had been denied. So fortunately, that one, there was a scheduling order that said no summary disposition motions, and you can file an appeal from that. It's a scheduling order, has the same force and effect as any other written order of the trial court. So again, it seems kind of strange to say that sometimes having an order in hand is a roadblock to the Court of Appeals, but it can be, and sometimes you just have to be creative and find a way around it. But fortunately, that does not happen. It used to happen somewhat regularly. Now it's very, very rare, but you might find yourself in that situation. I believe I have covered all the material I intended to cover today, but I'm happy to answer any other questions that anyone might have before we break.
There are not any current questions, but we can give it a second, see if anybody's typing frantically right now.
Well, in the meantime, again, I want to thank everybody for attending. Nice comment.
Yes, thank you.
I really want to thank everybody for coming. I really want to thank Madeline and her staff. You see Matt Hinkle down there. He was a tremendous help. This is my first webinar. I've had a couple Zoom hearings and things like that, but this was giving me nightmares with the technology glitch, and he really calmed me down. And I cannot thank Beth enough. I did most of the blabbing today, but she and I went back and forth on what topics to cover, and she had a number of good things that she thought should be covered and raised, and she really provided a lot of information that you heard today. So I can't thank Beth enough. She went above and beyond what's called for.
Thank you. And Madeline says that you do not look tired. So
thank you, Madeline. Okay, well, thanks again, Beth. Thanks, Matt. Thanks, Madeline. Thank you all for attending. Madeline mentioned that the video will be made of this and will be sent out to everybody. I know some people registered but couldn't attend. And I believe it will be on the MDTC YouTube channel. Again, thanks, Beth. Thanks, everybody. Really appreciate it. Hope to see you in person sometime soon.
Yes, hopefully. Thank you, Tim. Great job.